Well, hello everybody. Yes, it's still cold. Yes, the cold weather's still doing what it does to me. I did manage to get a couple smaller Lord Killian videos out, so I hope you enjoyed those. But for now, this document just dropped here in Kadrey v. Meta. This is sort of the OG AI cases. It's the one that's been around the longest. The rest of them are still kind of mired in discovery, and there's not much to talk about. But this one, they're through at least the fact discovery. But we've seen the progression that this one has taken from all their crazy claims about how AI contains little snippets and copies of their books and just pieces them together and things like that, which is not how it works. As I've covered before, all of that has been dismissed, and really the only thing left is the question of they obtained this Books 3 dataset through piracy, and therefore AI training is piracy. And again, I've been comparing it to the Google Books case and the HathiTrust case, where they said, no, that's only infringement if what you're doing with it is infringing. So the Authors Guild lost both of those cases because neither Google Books nor HathiTrust was doing infringing stuff with it. So the question here, and this is the only one that Meta didn't want dismissed because they specifically want it litigated, is it infringement to obtain copyrighted materials for the purpose of training an AI? Is training an AI an infringing thing? Or is it more like what Google Books and HathiTrust were doing? Well, the Kadrey plaintiffs, and this is the one that also has Sarah Silverman and all those others in it, those are kind of the bigger names. I think Mike Huckabee joined them, if I remember correctly, just a bunch of plaintiffs on this. They put in their third amended complaint. And so now Meta is responding to that. So they just have to keep amending these things to try and keep this case alive, because Meta really keeps owning them when it comes to a lot of these responses. So this is their motion to dismiss based on the third amended complaint. And again, when you're following along with these, use the blue page numbers at the top. That's the actual page number in the PDF file I'm linking to. So don't try to follow the ones at the bottom because they're different. So after you go through the table of contents and everything, you're on page 6. And so the plaintiffs allege that Meta violated the DMCA by removing the copyright management information, CMI, from their books before using them as training data. And this is something before we've seen the DMCA used for in a lot of things. Oh, you strip the DRM out of it to make a backup copy, and oh, that's against law. The courts have already thrown that out. It's like, no, if it's just for personal reasons, for backup reasons, or because you want to read your ebook on a different device than the one you bought it on, and you strip away the DRM to do that, that's fine because that's not infringing. You're reading a book that you paid for. But they're saying that Meta did so to induce, facilitate, or conceal its own infringement and that of others. So they're saying that this whole Llama LLM does all this infringing stuff, and the reason they took out the CMI was because they were hiding what they were doing. Plaintiffs failed to allege that they were injured by Meta's removal of CMI, and that's an important thing because if you want to file a lawsuit against someone, you got to show damages, right? How were they damaged by it? So Meta gets all these books, and they don't put the whole book into the AI training. They divide it down into chunks. And for the chunks, they remove that CMI because that would be totally confusing for the AI to train it on. Well, they're saying they were damaged by that, but how? So they're claiming they violated the California Comprehensive Computer Data Access and Fraud Act, or CDAFA, but they say that's merely copyright infringement by another name. They frame the claim in terms of Meta's unauthorized access to their copyrighted works, but access here just means copy. CDAFA prohibits unauthorized intrusion into plaintiffs' computer systems or data. It doesn't apply to third-party datasets on third-party systems. So CDAFA is an anti-hacking thing. Like if they had hacked into Sarah Silverman's computer, grabbed her book and put that in the training corp. Yeah, okay, they hacked into her computer. That's not what happened. They downloaded it. And so they say plaintiff's new theory of copyright infringement contains no allegation much less facts, plausibly establishing that Meta distributed through seeding any of plaintiffs' works at issue. And we'll get to what seeding is in a little bit. Plaintiffs do not plead a single instance in which any part of any book was in fact downloaded by a third party from Meta via torrent, much less that plaintiffs' books were somehow distributed by Meta. Meta does not seek dismissal of that claim here. Meta looks forward to setting the record straight and debunking this meritless allegation on summary judgment. And again, this is part of what they want litigated. They want the courts to say it's fine to obtain copyrighted information without permission for the purpose of AI training, because AI training is non-infringing. It's a fair use. That's what they're going for. They want to be put alongside HathiTrust and Google Books, not among big pirates who just swipe everything and give it to everyone else without authorization. All right, so going over here to page 8, the plaintiffs are now alleging that Meta removed CMI from books included in that dataset to facilitate training its Llama models by cleaning them for easier ingestion and also to reduce the chance that the models will memorize CMI, because one thing you don't want to happen is for the LLM to respond to something and then say, hey, this is copyright of someone else when it isn't. That would be insane. But they say that Meta knew that this would induce, enable, facilitate, or conceal its own copyright infringement or the copyright infringement of others. Plaintiff's revamped DMCA claim is not expressly tied to the prior theory rejected by the court that every Llama output is an infringing derivative of the model's training data. Because again, that's not how it works, so the court threw it out. But, just like the prior claim, the new claim presupposes that others have used Llama to generate outputs that infringe plaintiffs' books, without actually identifying a single example that this ever occurred. That is the same omission that doomed plaintiffs' earlier DMCA claims. So they allege that Meta knowingly accessed and used data owned by plaintiffs, specifically Meta's downloading of portions of LibGen and other shadow library data, which plaintiffs allege contain their copyrighted works via torrent systems and alleged seeding of that data. So the way BitTorrent works is you got a massively large file you want to send out to people, and you don't want to use a lot of resources to do it. So let's say it's a Linux Mint ISO, perfectly legal, this giant thing, and let's say it's just a brand new version and they just put it up. So there aren't a lot of seeders out there. Seeders are people who have an entire copy of the thing and can give it to others. You start downloading it. So you're downloading it in these tiny little pieces. Well, as you're downloading it, if you're downloading it, you're a leecher, not a seeder, but you can still seed the pieces that you've downloaded. So other people who are downloading it can get those pieces from you, and then they don't have to get them from the seeders. And that makes the protocol so efficient, because everyone is not only downloading it, they're giving pieces to everyone else as they download it. So even if Meta shut it off immediately when it finished, which you can set it up to do, there still would have been some seeding going on as they downloaded it. Now there are ways to stop that too, and we have no idea what Meta did. But this is a claim that's brand new. This resulted in Meta acting as a distribution point for other users of pirated books. So they participated in the piracy, and that's why they're pirates. In other words, plaintiffs allege that by accessing torrent systems to obtain training data, which plaintiffs characterize as pirated, unlicensed, hacked, downloaded, and or scraped versions of the infringed works, and sharing, distributing, and or uploading the same works in the process, Meta violated CADAFA. These same allegations now also form the basis for plaintiffs' new distribution theory of copyright infringement. So before, they were just alleging that they infringed on the works. They downloaded a pirated copy and then munged that through the AI training, and that was infringement. Now they're adding this seeding claim in to try and keep it all alive. So moving over to their argument on page 10, The TAC's third amended complaint. It alleges that Meta violated Section 1202b1 by removing CMI to conceal Meta's infringement of those works and unidentified infringement of others. The court expressed its skepticism regarding this claim at the hearing on plaintiff's motion for leave to amend. Wouldn't it be great if we had video of that? And they quote Judge Vincent Chabria saying, "I may be a little skeptical about the merits of the DMCA claim, but we can deal with that on a motion to dismiss." Well, this is the motion to dismiss. Now we're dealing with it. Indeed, this theory doesn't add up. Plaintiffs allege no injury, nor do they plausibly articulate how removal of CMI from books prior to training could conceal or facilitate infringement, let alone that Meta acted with the requisite intent. Each of these omissions is fatal to plaintiff's DMCA claim. So how does just getting rid of the CMI in between the downloading and sending it into the AI training, how does that harm them? They don't even say. Then over on page 11, plaintiffs fail to plausibly plead any cognizable injury stemming from Meta's alleged removal of CMI from plaintiffs' asserted works. The TAC contains only a single threadbare assertion that the plaintiffs and the class have been injured. However, the mere removal of identifying information from a copyrighted work is not, in and of itself, a cognizable injury. And then over on page 13, it says 8 here at the bottom, but it's actually 13 of the PDF. This is where they're claiming that the plaintiffs have failed to state a claim, which is a good reason to dismiss. Plaintiffs' theory of CMI removal as infringement concealment is vague and nonsensical. There's no plausible explanation of how the presence or absence of CMI in training data is supposed to correlate with revealing Meta's alleged infringement. Tellingly, though fact discovery has closed, the TAC does not cite to any documents or deposition testimony supporting plaintiff's theory that Meta removed CMI to aid or conceal infringement. Yet at the same time, plaintiffs acknowledge that removal of CMI facilitates training, which is inconsistent with their theory of concealment. So they're saying that the whole reason they took out this CMI was because they were trying to hide what they were doing, which means they knew they were doing something wrong, and that goes to intent and that proves everything. But they admitted that you have to do that to train the AI. So there's your reason right there. There's your intent not to conceal infringement, but to train an AI. Plaintiffs identify no instance in which the removal of CMI has aided or concealed infringement because they still allege no instance in which Llama has ever been used to generate an infringing output, much less one that infringes plaintiffs' at issue works. And then here at the bottom of, not page 9, page 14, Meta voluntarily published that it used the Books 3 dataset containing text from plaintiffs' books to train Llama 1, a fact which was the premise of the original complaint. It is irrelevant whether Meta later removed CMI from other datasets used to train Llama 3, because by then plaintiffs already knew that Meta had used a dataset containing text from their books. There simply is no plausible basis to conclude that Meta's removal of CMI from pre-training data aided or concealed infringement of plaintiffs' at issue works, let alone that Meta's actions were undertaken for this purpose. The claim must be dismissed. They also failed to state a claim for the violation of CADAFA. Torrenting and alleged seeding of portions of LibGen as a violation of CADAFA is akin to trying to fit a square peg into a round hole. CADAFA is primarily an anti-hacking statute intended to prohibit the unauthorized use of any computer system for improper or illegitimate purpose. So they would have had to hack into the plaintiff's computers in order for that to be relevant. So over at the bottom of page 16, plaintiff's CADAFA claim thus involves works within the subject matter of copyright, easily satisfying the first prong of the preemption test. If it's a copyright issue, it's not a CADAFA violation. Those are two different things. As to the second prong of the test, the state cause of action must protect rights which are qualitatively different from the copyright rights. The state claim must have an extra element which changes the nature of the action. And it doesn't. Essentially, they claim that Meta downloaded, copied their infringed works from unauthorized websites and distributed them without their permission. Both acts fall squarely within the Copyright Act. Indeed, this is nothing more than a transparent reframing of their core copyright claim. So they're just making a DMCA claim and they're trying to disguise it as a hacking claim. Basically, they want the court to consider that piracy is a form of hacking. If you go to the Pirate Bay and you torrent something that I did, and I didn't give you permission to get whatever it was that I did, a video of mine or whatever, then that to them is exactly the same as if you'd hacked into my computer and swiped it. And that's ridiculous. All right, and the bottom of page 18, they fail to plausibly allege a violation. The statute requires that the claimant be the owner or lessee of the computer, computer system, computer network, computer program, or data allegedly accessed without permission. But plaintiffs do not allege this in the TAC because they cannot. Instead, at most, plaintiffs allege that Meta downloaded datasets created by third parties from computer systems operated by third parties. And since the claimant is not the owner of the actual systems themselves, it doesn't apply. Now, they're going to try to worm it in and say, well, it's the data, but it's the data from the machine. And that's not what it means. And I don't think the court's going to buy that argument. All right, almost done here. Over on page 20, plaintiffs do not allege the requisite damage or loss to support their CADAFA claim. CADAFA contemplates some damage to the computer system network, program, or data. In conclusory fashion, plaintiffs allege that they have been harmed in an amount to be determined at trial, including but not limited to lost royalties, reputational damages, and other consequential losses, which is insufficient. For the foregoing reasons, Meta asks the court to dismiss with prejudice these claims. So we'll have to see what Judge Chabria says about this. I've been impressed by him. He's pretty much a no-nonsense guy, not only in this case, but a few others I've seen him on. And the thing about this is, having to kind of keep morphing this case to keep it alive, they've now turned it into a copyright case, and it's now indistinguishable from any other copyright case. You know, when they sue a grandma or a 7-year-old girl because, they downloaded a song from the internet and they say, now you're a pirate. Even if they succeed in this, that's basically what they'll be doing, meaning that this case is no longer about AI. They've shaved so many things away that the AI portion has nothing to do with it anymore. It's just a case of, you pirated Books 3 or LibGen or whichever one it was. You got it from a torrent site, that means you're a pirate, and now it's a typical piracy case. And it won't be the precedent they want to be able to go after AI. And also they're trying to equate piracy with the hacking of their systems, which I don't think is going to fly. Those are two different things. The law distinguishes between them. So I don't think the judge will be very impressed by this. So we've got all these other AI cases that aren't as far along as this one. I think they're going to be taking judicial notice of what happens here, because they seem to be going the same way anyway. And they're looking at all of these arguments and how they have to morph, and they're like, well, that applies to these other cases too, don't they? That applies to Claude AI and OpenAI and Stable Diffusion. It's the same arguments. It's the same progress. Whichever side loses, I'm sure it's going to go up to the Ninth Circuit. And it may or may not go to SCOTUS from there, because SCOTUS doesn't take every case. So who knows with that. But once it's in the Ninth Circuit, not only will it be that region, other circuits will be taking judicial notice of it. And so I think some of the cases are in like the Second Circuit and the Fourth Circuit. They'll either all take notice of it and conclude together the same way, which basically makes it precedent. Or if one of them goes the other way, that's a circuit split. And that's where the Supreme Court would probably step in. So that's where we are. It's just getting ridiculous because the AI cases are becoming less and less about AI. There was nothing about AI in any of those claims. Nothing. Nothing. So we'll have to see how it goes. So please stay tuned for that. Thank you so very much for watching. Comments for the Comic God, shares for the Share Throne. Please hit like, subscribe, and the bell. And of course, go to donate.pagosity.tv. Keep me doing what I do with one-time donations or by becoming a regular supporter. Get these videos early and ad-free. Other benefits, so please check those out. Thank you so very much for watching. Stay strong and be free.